just gonna be you and me.
It says it's live now, so.
Okay. Be careful what I say. And we'll leave just 5 more minutes before to allow people to join. And then we're going to kick off in a minute, Philip. Just when it gets to about 2 more minutes, and then we can kick off and I'll start asking you the questions and introduce ourselves to everybody.
That sounds good.
Okay, Philip, I think we've got notification from quite a few people that we are now live. So I just want to welcome everybody today to our first ever Farringford Legal LinkedIn live session. And today we are going to be talking about SEIS or EIS and which is the best for your SME. My name is Sarah Jane Butler and I'm the founder of Farringford Legal. We are a small boutique law firm that specialises in looking after SMEs and helping them to grow. And I'm really pleased today to be joined by Philip Hare, who is part of Philip Hare and Associates that specialises solely in SEIS, EIS, VCTs since they were first introduced back in 1994, 95 and 2012. Today, I'm going to be asking Philip lots of questions. If anybody does have any questions that you wish to ask, please could you put it in the comments box? It would be really helpful for you to let us know who you are, whether your business is, whether you're investors looking to invest in an SEIS or EIS scheme. Any questions that you have, there is no such thing as a stupid question. We are all here to learn. I think one of the things that I found from most of the companies that I speak to is that a lot of people aren't aware of actually the intricacies of SEIS and EIS. And many people don't understand what it means to their business or also to their investments. So without much further ado, I'm going to start my questioning off of Philip. I'm going to interrogate him. So I guess the most simplest question is, what is an SEIS scheme and an EIS scheme, and how do they work?
Thank you. No, very pleased to be on here and to answer questions, and particularly pleased to be part of your first ever LinkedIn live session.
Thank you.
So yes, as you said, I've been advising on the EIS and SEIS and VCTs since their inception. That's when I began my career. I was at PwC for 20 years and then 10 years ago, I left to set up, well, basically to work for myself, but it's turned into a business, and there's 9 of us that all we do is help companies and their investors meet these requirements. And as you said, there are a lot of intricacies here and lots of traps for the unwary. But just to start with the very basics as to what they are, although it's called a scheme, what it actually is, it's an ability to claim tax relief by investors who invest their cash for shares in the right sort of companies. So they have to be small, generally early stage, with growth prospects, carrying on the right sort of trading activities. And you have to have the right sort of shares for those as well. And the cash has to be used for organic growth of those companies. So the seed EIS, the SEIS, is for the really early stage companies. So they have to be doing their first business. They have to be less than 3 years old, that business. They also have to be quite small. So, for example, they have to have fewer than 25 employees. Their gross assets, so the balance sheet has to have assets of no more than £350,000, and they can only raise up to £250,000 of this tax advantage money, including other sort of de minimis state aids and risk subsidies. But if you're an investor and you qualify for that and subscribe for shares in an SEIS company, then as long as the company goes through the right processes, then you can get a tax rebate of 50% of your subscription money for your investment. So that's kind of an upfront relief. Then there's other tax reliefs that go along with it. So if it's all successful and you have a successful exit after 3 years, any capital gain on those shares is tax-free. And that potentially is the biggest amount of tax relief that you can get. You can also get loss relief if everything goes horribly wrong. That gives you some downside protection. And there's also the ability, if you have realized a capital gain at a similar time to making the investment, then you can shelter part of that gain by making an SEIS investment. So that's the tax relief for the early stage SEIS companies. Now, EIS is the sort of older brother of SEIS. It's been going along since 1994. It's just past its 30th year. And this is for slightly older, slightly bigger companies. And the tax relief for that is an upfront 30% income tax relief. So if I put £1,000, subscribe for shares for £1,000, I can reduce my income tax bill for that tax year by £300. There's a similar tax relief on exit. So on a successful exit, that gain is tax-free. I can also get loss relief if it all goes horribly wrong and I lose my money. And also, again, if I've got a capital gain that I've realised, usually in the last 3 years before the investment, then I can defer that gain and not pay the tax on that gain while my money is in the EIS company. An EIS company will be somewhat larger, so it can have usually up to 250 employees, although in some cases it can be 500. It can be up to 7 years old generally when you make the investment, but there are times you can extend that time limit. And then also it's got an asset test, but this time the gross assets of the company must not exceed £15 million at the time of the investment. So you'll see that's companies which are quite a bit bigger. You're on mute, SJ.
Apologies. Does everybody qualify, or are there certain companies that aren't able to access this kind of scheme?
Yeah, so when you're looking at the companies, there are a whole raft of requirements for them to meet. So the most common reason why companies don't meet it is the age limit. And this is an EU state aid rule, which was brought in 2015, which we still haven't exited from. So it still applies today. And so broadly, the trade must be less than 7 years old, or the company must not have traded for more than 7 years. For what's called knowledge-intensive companies, so companies doing a lot of R&D work, so your life sciences or whatever, they can be up to 10 years old and still be in their initial investing period. So that's the most common reason for failing. There's the size. If you're over the size limits, then obviously you won't qualify either. But what you need to do is consider what is your activity, what's the trade of the company. So you have to have a qualifying trade, or you'll be carrying out R&D, which is leading to a qualifying trade. And the way that the law works is that all trades qualify, apart from a list of things which don't. So You qualify unless. So the sorts of things which don't qualify are things which are more like an investment activity. So there are holding shares and land and so on is not a qualifying activity. There are also types of trades which perhaps may be regarded as asset-backed and therefore perhaps a lower risk, and they're not quite so worthy of the tax relief. So there'll be trades such as property development, managing hotels, nursing homes, farming, market gardening, those sorts of things which tend to have some kind of asset back to them. There are also trades which have got some other subsidies, so coal mining, shipbuilding, steel production. Most or pretty much every energy activity in the sense of your generating activity will also be excluded. And then which will interest you and me, SJ, is that lawyers and accountants don't qualify either. There's too many of us, or we don't actually need the money anyway. And then there are some other ones. So if you've there's one or two that've got kind of an exclusion, but then you can get out of the exclusion. So a lot of financial activities don't qualify. So if you're lending money or providing credit, sort of hire purchases, debt factoring, that sort of thing, that doesn't qualify. But companies in the financial space can qualify if what they're doing is being an intermediary, or if they like a platform between borrowers and lenders, for example, or they're an advisor in that space, that can qualify as well.
Okay, so we have a lot of clients that we work with who are at a very, very early stage, and they're obviously looking to raise finance from angel investors, and they're obviously looking to be able to make themselves as attractive as possible. What would be your message to them to actually start going out there and have discussions with their investors about what the benefits are, and how, as you said, there's plenty of from loss if something was to go badly, but equally from the start there are benefits for investors. But how would you suggest to SMEs they go about talking to potential investors about what they can receive?
Yeah, so I think the first thing is for the companies to check whether they're likely to be a qualifying company. So to go through some of these things, like what their size is, what their age is, what the nature of their activities is, and then also about how much money do they really need and how are they going to use it, because there are some restrictions on what you can use the money for. You can't use the money to buy another business or to buy intellectual property already in use in the trade, for example. So it's about organic growth of the company. So you need to have some kind of business plan as to why you're raising the money, what you're going to do with it, and then some kind of idea as to whether you're likely to be a qualifying company. Because if you go to an investor and you don't know that, that's quite difficult. But if you're armed with that, then there are some investors who are very savvy. They know what the tax reliefs are. Some people are very seasoned investors in this. But other people that, sort of more friends at an early stage company might sort of seek, then this can be very attractive to them. And so you can find online or also on our website, for example, there is a list of what the tax reliefs are. So it will tell you how much you can claim as a rebate against your income tax in your investment, and then talk about things like the capital gains tax-free exit and the loss relief and so on. Most people focus, as it were, on the upfront relief, the either the 30% for EIS or 50% for SEIS, because that sort of you get it sooner. But actually, you shouldn't forget the other tax reliefs, which is the capital gains free exit after 3 years, and the loss relief, the downside protection.
And just from a legal perspective, one of the things that is really important there's sort of 3 areas in the terms of the legal documentation and processes that people should be aware of. The first is to make sure that when you are bringing on an investor, that your shareholders, you need to have a shareholders agreement, quite clearly, but equally you've got to make sure that that shareholders agreement aligns with the SEIS, EIS rules. Second of all, if you do have an investment agreement, you've got to include the details of the investment, the rights that are attached to those shares, and any conditions to that investment. And third, and not least, you need to look at your articles of association. So it may be that those need amending to ensure that you are complying with the SEIS, EIS requirements. So it's not just a case of just issuing shares and saying, right, here they are, they now comply with SEIS, EIS. They don't. you need to go through each of the various tick boxes to make sure that you have the right documentation in place, and that you've actually equally made sure that you've issued out those certificates. Now, one of the things I was going to say, Philip, which we've come across, is where people have yet to start trading yet, but have received investment on the basis of an SEIS scheme. Can you just explain what happens in that instance if you haven't actually started trading yet?
Yeah, I will come back to what you just said about the documents and so on, because I've got some few points to make on that.
Sure.
But just on a company can qualify either it's already trading and its trade is either less than 3 years for SEIS or less than 7 years for EIS. But you can also qualify if you're still in the preparation to trade stage. So you're putting together your bit, your plan. So you might be doing R&D work, for example, creating some kind of technology or whatever. But even if you're in sort of retail or something like that, and you're looking for your shop and your staff, and you're still preparing to trade, and you can raise the money at that stage. For EIS, you must, unless you're doing R&D, any other trade that you're preparing for, it must commence within 2 years of the issue of shares. Otherwise, it doesn't qualify. So okay. If I'm in retail doing a shop, I would need to make sure my shop was open and I was selling my products within 2 years of the issue of the shares to the EIS investors.
Okay. And sorry, go back to the legal documentation.
So they're really important. What we find in terms of the process is there's usually negotiations between the company and the investors as to what the nature of that investment should look like. Now, a very early stage is quite often that there's only one class of shares in the company, they're ordinary shares, and everybody's the same. And generally that will work for SEIS and EIS. That's the Articles of Association. If you've only got one class of shares, you're probably all right. But if you're entering into a shareholders agreement, you need to make sure that they don't have things which the revenue think are offensive to the rules. So if you've got kind of risk protection clauses or something like that, then you need to be quite careful about those. If there's any suggestion that you'll get your money back, then you won't qualify for these tax reliefs, because it's got to be money that you are putting wholly at risk. But in terms of then, you sort of do your deal with your investors to what might want a slightly different class of shares for various reasons. That is possible under SEIS and EIS, but you do need to word the Articles of Association very carefully to make sure that those shares are what are called eligible shares for SEIS and EIS, and that's about who has a priority to receive proceeds on a sale or to dividends and that kind of thing. You also have to make sure you don't have things like anti-dilution rights, because you won't get tax relief if you've got those.
And in terms of registering your business for SEIS, what do you need and who do you need to contact, and what documentation do you need to provide?
It's a common question about how do I register my company for this, and it's not quite the right sort of language, to be honest, because it's not, you don't register the company and I always qualify. It's not like that. And what it is that every investment has to qualify on its own merits. So what you can do is, before you raise the investment, but when you know roughly who your investors are likely to be, so you're nearly investment ready, you can apply to HMRC for what's called advance assurance. So an assurance from them in advance of the investment being made that the company is a qualifying company, that the shares are qualifying sorts of shares, and you're raising the cash for the right sort of purposes. That's called an advance assurance. The revenue are taking about 6 weeks on average to respond to those these days. So there is some time scale there. You need to send a whole load of documents in with it. So it's about your business plan, your cash flow forecast, your draft legals, your articles of association, your shareholders agreement, and so on. Plus narrative about why you think you've got a qualifying trade and how you're going to use the money and so on. Of course, we do that as our firm. We do that for most of our clients, because investors like the comfort of the revenue having looked at it first. It doesn't actually provide any assurance that any particular investor will themselves get the tax relief, because it also depends on their own circumstances and how you actually implement this. And one of the things I was going to say, and it's people trip themselves up on this, that you don't get the tax relief if the shares are issued before the company receives the payment. So the company must receive the cash subscription before the shares are issued, or at the same time. Otherwise, it doesn't qualify. Even if it comes in the day later, it doesn't qualify. So that's beforehand. That now, after the investment is made, then in order for the investors to claim the tax relief, then you must submit a compliance statement saying this is the company and these are the shares we've issued to these people. So it identifies the investors, each one, how many shares they've subscribed for, how much they have invested. There are time limits for that. So you can't do it unless the company has already been trading for 4 months. Alternatively, for SEIS, you can submit that once you've spent 70% of the SEIS money that has been raised. If you have an advance assurance, then what you do is you point to that advance assurance and confirm that nothing has changed from what you said there. You just give the latest version of, the final version of the Articles of Association, the shareholders agreement, and so on. And hopefully then that's a quicker process. But you don't actually need to have had advance assurance before. It's not obligatory. It's a question of fact whether you actually qualify. So somewhere around about a third of our clients don't go for advance assurance. They just make the submission afterwards, or we do it for them. And they, so we have to then put in similar information as though it were advance assurance, and describing the trade, putting the business plan, the cash flow forecast in, and all of those other good documents. Now, the revenue will look at those applications. They may have some questions. We try to avoid them because we sort of know what the sort of touchy areas are. But about a third of the time we do get questions. That's just because of the nature of the way the revenue work. Hopefully you can deal with them and answer them satisfactorily. And then if it gets approved, then what happens is the revenue give the company a certificate. It's either an SEIS 2 or an EIS 2, depending on which of the two it is. And that authorizes the company to issue SEIS or EIS tax certificates, one to each of the investors for their particular investment. And say that authorization belongs to that particular investment, that particular day, those particular shares. It doesn't necessarily mean that if the company were to raise money next year, that it will also qualify and also get the certificates, because it will depend on the circumstances at the time.
Well, that brings me on to my next question. If the company decides to do a further investment round the following year, can they use the same scheme, or do they have to go through the same process again?
You don't have to have advance assurance again, but sometimes investors ask companies to do that. You may take a view quite reasonably that if nothing really has changed and it's clearly within all the size limits, then you don't need to have an advance assurance. And what you do is you then raise the money, issue the shares, and then submit the compliance statement, the appropriate one for SEIS or EIS. Now, I've said that SEIS has a limit of £250,000 of total that a company can receive of SEIS money. Mm-hmm. After that, then you have to go into EIS if you want a tax-advantaged investment. And chances are the company's bigger anyway, so it falls within the EIS criteria rather than the SEIS. But not all companies use up the whole of their £250,000 SEIS allowance. They may have a part of SEIS and then they go into EIS. Once you have issued shares to EIS investors, you can't raise any more SEIS money, even if you haven't used up the whole £250,000 limit. And the other thing to say about this, and you'll see all the intricacies here, that you cannot issue SEIS shares and EIS shares on the same day. You have to do all your EIS on a separate earlier day, issue those shares, and then the next day you can start raising EIS money and issue those share certificates for that.
Excellent. And if you've got to the end of your 7 years and you've done one raise already, what is the likelihood of being able to, say you get to 8 years, just you've tip over, what is the likelihood of being able to raise further, unless you are a life science, as we've already discussed, where you've got slightly longer? What is the likelihood of getting further EIS?
Yes, so the age limit is usually the reason why companies don't qualify. But the way it's supposed to work is that if you raise your first tax advantage money within the 7 years of your first commercial sale of any sort, then you can raise further money outside of that 7-year period, so long as you can prove it's for the same business activities as that first investment was made. So it depends how the company evolves as you go on. If the trade changes, then obviously you can't meet that requirement. But if the trade is roughly the same, it might be enhanced, so you're doing it in a better way. But if it's roughly the same sort of services to roughly the same sort of clients, then that should be regarded as this follow-on money, and therefore you should meet the age requirement that way.
And what do you think are the biggest mistakes that people make when they are trying to use SEIS, EIS to attract investors?
I've already mentioned one, which is issuing the shares before we have payment. We find that sometimes. People don't always understand, for example, that the shares have to have particular rights, or rather mustn't have certain rights.
Correct.
So they've drafted the legal documents wrongly. And the trouble is there's no possibility of correcting it either, because it has to qualify all through the period. Sometimes they don't realise that changes to the nature of the activities can disqualify you, or if you introduce a new class of shares, that can disqualify you, or if you enter into joint venture arrangements or enter into a partnership with another business, all of those things have the possibility of saying that you no longer qualify and the tax relief is withdrawn. So there are a whole range of things. I mean, some of the things you do are deliberate. So, for example, if you sell your shares early before the end of the 3-year period, then you lose your tax reliefs. But it may be that actually you've had an offer that you can't refuse. So you get such a big return for your investment that you'll say, well, that's fine. I'm happy to pay the tax relief back because I've made a nice profit on my shares.
On the card cover thing. And I think it's really important when we've been dealing with this is, as you say, it's the stages that needs to happen. So you can't issue the shares until you've done the payment. It's also making sure, as you say, that the shares are eligible and it's very clear. It's also making sure that actually all the documents kind of work to that effect. So as you say, if you try putting in different rights to different shares or fettering them in any way, or the preemption rights, except changing those preemption rights, those are all things that need to be looked at. So it is super important that when you're looking at the legal documentation and you're doing an investment raise, you make sure that your investment agreement, your shareholders agreement articles do actually all point in the same directions, because they, as you say, Philip, they all have to be added in if you're going for advanced assurance. And obviously there are questions, and we have received questions when we've done these for clients in the past. From an investor's point of view, clearly there's a tax benefit, and there's a lot of angel investors who are very savvy out there who are making the most of it. What would your advice be for an investor looking at companies who are using an SEIS CIS scheme?
So, I mean, obviously investors can discuss with companies, certain conditions. So if I were an investor, I might want to say, I would like to have the right to know about certain things before they happen. So, if you're thinking of changing your nature of your trade, for example, that could affect my tax relief. And because the tax relief is large, I need to know about that. So sometimes an investor might ask for information rights. It is actually possible for investors to have SEIS or EIS relief and actually to be an observer on the board of directors, or even to be a director if you do things in the right order. In fact, the EIS particularly is designed to try and attract talent to these companies as well as capital. So what is colloquially known as the business angel exemption here is that what it says is that I'm an outside investor, I want to put money into this company, but I'm actually bringing talent, so I can be on the board as well, and I can qualify for the EIS tax relief and be a director, provided that I wasn't previously connected with the company and I had my shares issued at the time when I wasn't ever entitled to remuneration from the company. Then you can qualify, because normally a director and an employee won't qualify for EIS. So the whole idea about this is to try and help grow these companies, to bring money and talent to them.
Okay. And correct me if I'm wrong, but if somebody's a family member, they also can't benefit from EIS. Is that correct?
Yeah, usually they can't. No. So a founder won't normally qualify themselves because they will have more than 30% of the company. That's one of the rules to qualify. You have to have 30% or less interest in the company. And most founders don't want to give away 70% of the company right from the beginning. But you could have a founders team, four founders in a business, all who have 25% to begin with, and they can all qualify themselves if you get it right. So that's quite an interesting one.
Okay.
But in terms of what you're asking about, which is about who else, my friends and family, can they invest and can they get the tax relief? So what you have to aggregate all these is with your associates. So when you're looking at the 30% rule, whether you're looking at whether you're employee or director and so on, you aggregate your holding with those of your associates, and they will be spouses, and they will be ascendants, so parents and grandparents, and there'll be descendants, so children and grandchildren, so on. But it doesn't include siblings; they're not associated with each other, and neither are in-laws and uncles, aunts, and cousins, those sort of things. So more distant relatives; they're not associates. So you could have, say 4 brothers and sisters, again, all have 25% of a company, and they can all qualify.
Okay. And you mentioned that at the moment it's taking sort of approximately 6 weeks for HMRC to come back were a company to decide to try and get advance assurance from HMRC. Roughly how long does the process take if people are looking to try and get investment, bearing in mind the 6 weeks HMRC delay? How long would you advise people to be to plan for when looking to put this in place?
We would normally say it's a 3-month process from start to finish, allowing for some questions and so on. The way we work is that a client comes to us and we have a look through everything, and we advise them about how they present themselves. So it's normally a couple of weeks process that we go through with the client, saying we can present this in a better way, or we can talk to you about the share rights or other things which are critical here, and we try to get them correct to begin with before we make the application. And those couple of weeks beforehand are really valuable here, because we want to avoid, if possible, getting questions or things that could trip you up. It doesn't mean we never get questions, because we do about a third of the time. But what we try and head off most of those, and so it's probably about a 2-week process that we're going through with the company. It's legal documents with lawyers such as yourselves, looking at their cash flow forecasts, their business plan, looking at the sort of investors, what percentage they've got, and so on. And sometimes we're doing a bit of, actually the founders could benefit here if we do it right, and those sorts of questions. So we add that sort of value in those 2-week process. Then we make the submission to the Revenue for Advance Assurance. We hope to get it back for 5 to 6 weeks, something like that. Just occasionally you're surprised we get it back quicker, but it's you can never tell. It just depends which desk it lands on. And then hopefully we get an advance assurance. If there's a round of questions, we try and deal with those quite quickly, and hope for an answer comes back positively after that. Then at that point, the company can then approach the investor and say, now we qualify, here's my advance assurance. They advance the money to the company, collect it all in one go if possible, or split it between SEIS and EIS if you qualify for both in the right way, and issue the shares in the right order to make sure that you don't breach the SEIS limits and things like that. And
so
then you can apply for the tax certificates afterwards.
Go for that. So last year, the rules slightly changed in the new financial year. Can you just explain what those changes were and what it would have meant to people?
Yeah. So the changes which were effective from 6th of April 2023 are for the SEIS only, not the EIS. And the reason for that, we have latitude to change that because it's what's called a de minimis aid. So it's not subject to EU interference. So the old rule used to be that the trade had to be less than 2 years old. And now that's changed to 3 years. It's recognised that particularly female founders probably take longer before they're ready to receive outside money. So that was one of the reasons why we were lobbying for that. It used to have a limit of £150,000 of SEIS money. That's gone up to 250,000. And of course, that's partly inflation, because that 150,000 limit was in since 2012. And so it's a good thing that that's increased. That's a better sort of sum of money to get a company going. Then the gross assets has gone up to £350,000 from £250,000. And the other thing is that as far as the investors go, it used to be they could invest up to £100,000 of SEIS money in any tax year. That went up to £200,000. So it's the SEIS where those changes have been. There's been no changes to EIS because they, according to civil servants, are still subject to EU state aid restrictions. And so any changes to those sorts of things have to get the approval of Brussels, in their view.
Okay, that might take quite a long time. And what would you say? So we had a question from somebody that said, can I just do this on my own? Because obviously, I'm wary of fees and I don't have the money to pay for advisors, etc. I mean, clearly from our perspective, we would say, please don't do that. It's really important that you get the legal documentation correct. But Philip, I mean, do you think somebody can do this by themselves?
It depends on really, if they've got a background in the right sort of area, so financial advice or something, they might probably just about be able to do it. But the trouble is, there's so many traps for the unwary, and there is no mechanism to correct a mistake, unfortunately, even however innocent it is. That's the real problem. So really, you need people who do this day in, day out to tick all the boxes, say, I know what I'm looking for here. I know the sort of things that are red flags to the revenue. And let's see if we can remove them, or at least describe things in a better way. So obviously, I mean, I've got a vested interest in it, as you do have, but my advice is, you do seek advice. We mostly do this for the clients, because usually it's an entrepreneur. Their time is occupied with other things driving the business forward, and they're quite glad to hand it over to somebody else. But we do also work with our clients that they actually make the submission, but we handhold them through it. So we tell them what they need to do, and then we'll have a look at it and say what we think about it, and then they can make the submission as well. So we are flexible in what we do. Some people who've got a bit more handle on these things, then they might just ask us about a couple of areas, and that's fine. We can work on that basis. But I always recommend that somebody else who knows what they're doing ought to have a look over it one way or the other.
Absolutely. Well, so we're coming up to sort of 40 minutes now. I think we've sort of gone through most of the questions that we've received prior to today. Is there any sort of final advice that you would give to entrepreneurs, startups out there who are looking to make the most out of their investments?
Yeah, I would say talk to other entrepreneurs that you know as well. Because they may not know, but actually some of them do, and they may have already raised money, and they can give you the benefit of their experience of this. It makes a huge difference as to how much money people can raise for their companies. We get, I would say, the majority of our clients tell us that they wouldn't have a business if these tax reliefs weren't there. And some people say, I wish I knew it early about this, because I struggled to get my company going. And sometimes they're too late for the 3-year rule for SEIS. So yes, spread the word. Talk to people who know what they're doing, who've done it before, and I think that will encourage you, to take this forward. And the tax reliefs are really, really generous. They're the envy of the rest of the world, basically.
No, they definitely are. And as somebody, so in my previous business, prior to running Farringford Legal, I raised EIS funding, and I have to say it was an absolute godsend. And we did exactly, we had to go for advance assurance, and we had to make sure our shareholders agreement was all in place, and our investment agreement worked and had the right eligible shares. And so I've actually been there myself as a founder and gone through this whole process myself. And I was also one of the people who got to the 7 years and tipped over the 7 years and had to convince HMRC that it was still the same activity and we were still trading. So I know all the pitfalls. I've been advised on the pitfalls. And actually, I wouldn't have been able to do it unless we'd had our advisors. Even as a lawyer myself, understanding the legal documentation, the tax side of it and the EIS side of it was invaluable to have an advisor. So I 100% would recommend Philip and his crew, because I think it's one of these things that is really important that you have somebody who understands how this works. Thank you, Philip.
Just to emphasise
Sure.
that, so we will always have a conversation with companies for free to begin with, to see whether there are any showstoppers, and we can explain what the benefits are. So please approach us. There's a team of 9 of us, and I'm hoping to recruit a couple more very shortly. We're delighted to help these companies. We love what they're doing. We love this entrepreneurial spirit. We're still quite young ourselves and entrepreneurial. Compared with sort of other advisors, I don't think we're expensive, but we do pride ourselves on the service that we give our clients.
Yeah, that's why I like working. It's called affordable, practical solutions. That's that's our motto as well. Thank you so much. And if anybody who is out there listening to this wants to get further information, either on the tax side, please reach out to Philip on LinkedIn, or if you wish to have a look at your legal documents to make sure that they are up to date and cover everything that they need to, please contact either myself or my colleague Milan, because he has done quite a few of these as well in the past, and is very knowledgeable about these. So thanks again so much, Philip. I really appreciate your time today. Thank you for being part of our first LinkedIn Live. Hopefully we will have some more. If anybody has topics that they wish us to cover next time, please do email us or put a message into LinkedIn. But in the meantime, thank you very much for your time, Philip. Have a really good afternoon, and we'll be in touch soon.
No, really pleased to join. Thank you.
Cool. Thank you. All the best. Bye.
Bye.